Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. This is Tuesday, February 28th at 2 p.m. here in Conference Room 325 at the State Capitol. My name is David Tarnas. I'm the chair of this committee. We also have here our Vice Chair, Representative Greg Takayama, Member Representative Kanani Souza, and Member Representative Daniel Holt. Other members will be joining us presently. I would request that all testifiers limit their testimony to 2 minutes if you could, and I'll ask you to summarize at that point so we can get through all the testimony and also have time for questions and discussion. If you're testifying via Zoom, please keep yourself muted and your video off until I call you to testify, and then if after your testimony is complete, please mute yourself and turn your video off. If you need to check in with the technical staff here on any technical issues, you can use the chat function in Zoom for that purpose. But don't send me a note because I won't get the message. If you're disconnected unexpectedly, don't panic. Just come back in, join back again, and we'll try to fit you in when you come back onto Zoom. If you're testifying via Zoom and you're using background, please make sure there's no trademark or copyrighted images, because if that happens, YouTube kicks us off. And so it causes problems. So please don't use any copyrighted or trademark images. And as usual, please conduct yourself with best behavior, no profanity or uncivil behavior at all. It's okay to disagree, but let's not be disagreeable. We're all working together for the best interest of the people of Hawaii. So I appreciate all of your kokua in that regard. And I want to say thank you to our members for being here and joining us just now during my initial preparatory remarks, our Representative Sonny Ganadin and Representative John Mizuno. So thank you very much for everyone joining us. Let's go ahead and get started. First up, House Bill 777 relating to background checks. Authorizes the Department of Human Services to conduct national criminal background checks for current and prospective employees, volunteers, contractors, and contractors' employees, agents, and volunteers who are in positions that require close proximity to certain minors, young adults, or vulnerable adults. First up, we have testimony and support from the Department of Human Services. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Daisy Hartsfield. I'm the administrator for the Social Services Division in the Department of Human Services, and I'm testifying on behalf of our director, Kathy Betts. The department did submit written testimony in support of the bill and offered amendments, and I stand by the written testimony and available for any questions.
Thank you very much. And just in brief, your testimony is just to delete the term agent and replace it with either subcontractors, employees, or volunteers.
That is correct.
Okay, and that's because FBI,
they notified our Attorney General's office that they had issues with that language. It was overly broad, reviewed the statute and didn't feel that it was adequate enough, and so that's why we're making the amendment or suggesting the amendment.
Okay, great. Thanks for that explanation. Next, we have testimony with comments from Hawaii Civil Rights Commission. Testimony in support from Catholic Charities of Hawaii, and testimony in support from Dale Head. Please proceed.
Hello there. Can you hear me?
Yes, we can hear you. Please proceed.
Okay, criminal background checks. They're like a no-brainer. All employers should do this. That's what a homeowner association is. My testimony I put in there that we had an escaped murderer as a resident manager. This is dreadful. Before he was arrested and incarcerated, this clown, he sued me for organizing a homeowners revolt to get rid of him. It's dreadful. Being sued and taken to a small civil court, It cost the association $100,000 in legal fees, and he got away with 40 grand before he got arrested for the murder. And he did 6.5 years and got out on parole in Christmas Eve of 2021. So he got 6.5 years of what I call crime university. Hard time for the bad boys. This bill should pass as it is, okay? In fact, it should be mandatory, not may, if they want to. They should have to do that. Because otherwise they get their pantsuit off and they get another lunatic like we had. That's all I got to say. Thank you.
Thank you very much. Next, we have testimony and support from Dana Caave, Alan Garcia, Elmer Kai, Lisa Smith, and Christine Ola. Is there anyone else here wishing to testify on House Bill 777? If not, questions, members? Seeing none, we'll move on. Thanks very much. House Bill 823, relating to deaths within the correctional system. It expands the scope of inmate deaths that are to be reported to the governor and legislature, requires reports to be published on the Department of Corrections and Rehabilitation website, requires reports on the cause of death, and mandates public access to certain information within these reports. First up, we have testimony with comments from the Department of Public Safety. I got two people coming up here. I was going to say, who got there first?
I'm sorry, I'm Tommy Johnson, the
You're
Director of the
first.
Department of Public Safety.
Director, it's great to see you.
Thank you. That's Dr. Gavin Takanaka, our Healthcare Administrator.
Yes, I appreciate that.
I'm
Thank
going
you
to
very
regret
much.
having to take this, but I'm going to go ahead anyway. Real quick, I just wanted to state that we submitted comments on this bill. We may have been a little bit overzealous in mentioning the Office of Justice Programs and Bureau of Justice Assistance. There was one typo also on page 2 of our testimony in the second paragraph. It reads, as a hybrid Heath Insurance Probability and Accountability Act, that should be health. But to be honest, Heath is a pretty good candy bar. That's all I have. Thank you.
Thank you for your sense of humor. I appreciate that, sir, and thank you for your testimony. Next, we have testimony from the Hawaii Correctional System Oversight Commission. Welcome, Commissioner. The floor is yours. Please proceed.
Martha Torney for the commission, and I have more or less rewritten our testimony, and Tommy already alluded to it because I talked to him about it. Our previous testimony refers to comments submitted by the Department of Public Safety in previous hearings, and we were identifying flaws in those arguments. But now there's a new argument that has to do with the Bureau of Justice Assistance or the Bureau of Justice Statistics, saying that they don't release information the state submits on inmate deaths. Well, they're not allowed to, and they're not allowed to because the data is used for statistical purposes only, and in their guidelines they state, the term statistical purpose means the description, estimation, or analysis of characteristics of groups without identifying an individual organization that comprise those groups. The Bureau of Justice Assistance data collected nationwide for analysis and comparison between jurisdictions. This includes such items as arrest, convictions, and sentencing, which is public information in all states. So we just want to say that referring to the Department of Justice and their rules does not apply in this case whatsoever. Thank you.
Thank you very much. Next, we have testimony and support from Nikos Leverens with the Hawaii Health and Harm Reduction Center.
Aloha, Chair, Vice Chair, and members. Nikos Leverens with Hawaii Health and Harm Reduction Center. We strongly support this bill, and we believe that information pertaining to the death of inmates be released publicly as soon as possible. It's unfortunate that PSD has had a number of suicides in their facilities, including cases where there have been 7-figure judgments. So it's critical for this legislature to demand that such information be released in an expeditious fashion, particularly when we have practices where those who are in suicide watch are placed into solitary, which is really not, it's the antithesis of sound penological practices. Mahalo.
Thank you very much. Next, we have testimony and support from the Community Alliance on Prisons. Ms. Kat Brady, please proceed.
Aloha, Chair Tornes, Vice Chair Takayama, and members of the committee. Kat Brady testifying on behalf of Community Alliance on Prisons in strong support. We really believe that families are the invisibly incarcerated. So the way that they receive information about their loved ones who are incarcerated is really important. And at a prior hearing, the department said, well, the warden always calls. That's not always true from the people who we speak with. However, I looked on the web and I thought, who actually goes to deliver this really bad information? The Army and the police. And I went on a police website and, you know, they said using the phone to make death notification is cold-hearted and a sign of intellectual laziness. So I understand that we have people who are, you know, dying in Arizona and their families live here, but there are other ways that the department could actually nexus with people in that jurisdiction where the family is from to talk to a social worker there and say, you know, somebody died in Hawaii that's related to one of your residents. How do we actually, you know, do you have somebody that we can talk to who can go and talk to the family in person? Because it's really, really crucial. It's so cold-hearted to just receive either a message on your machine or, you know, a phone call from somebody from the prison. It's really important that we respect families. So thank you.
Thank you very much. And we have testimony in support from Ilima DaCosta with Ho'opono na Mea Ola. Testimony in support from Brian Black, Civil Beat Law Center for the Public Interest. Testimony in support from Opportunity Youth Action Hawaii, Leah De Los Santos. Testimony in support from Dana Kiawe, Will Karen, Nanea Lowe, Diana Bethel, and Christine Crawford. Is there anyone else here wishing to testify on House Bill 823? Seeing none, questions, members? Seeing none, we'll move on. Thank you very much. Next, House Bill 100, relating to criminal justice data sharing. It establishes a criminal justice data sharing working group to make recommendations for a statewide criminal justice data repository. First up, we have testimony from Aaron Harbinson. Dr. Harbison's with the Judiciary State of Hawaii. Please proceed.
Hi, Chair, Vice Chair, members of the committee. I'm Erin Harbinson, Director of the Criminal Justice Research Institute, and we submitted comments on the measure and stand by those comments, and I'm here for any additional questions you might have.
Thank you. Next, we have testimony with comments from the Attorney General. Philip Higdon.
Yes, sir.
Welcome.
Thank you.
Floor is yours. Please proceed.
Thank you, sir. Good afternoon, Chair, Vice Chair, and committee members. My name is Philip Higdon. I'm the acting administrator with the Hawaii Criminal Justice Data Center. We have provided comments to this bill, but I think it's important to note that by state statute, the Department of the Attorney General, the Hawaii Criminal Justice Data Center, is responsible for the repository of criminal justice information, arrest information, as well as conviction of adult information. By creating another working group, it appears that this is just a duplication of a working group or a committee that's already in existence, and that is the Hawaii Integrated Justice Information Sharing, HIJUS is what it's called. Everything proposed in the bill we can expand on. HIJUS, the executive committee, can expand on. In fact, prior testimony, the individuals that supported this bill actually are part of the executive committee of the HIJUS committee. So thank you for your time. I'll be happy to answer any questions if you have any. Thank you.
Thank you. And just for those who are watching and they're wondering what HIJUS is, just to say it again, repeating what we just heard from Mr. Higdon, HIJUS is the Hawaii Integrated Justice Information Sharing. HIJUS, H-I-J-I-S. So you might hear that again in the testimony. Thank you very much. Next, we have testimony in support from the Department of Public Safety. For those who didn't hear, because they can't hear because you're not up here, I'll just say that Director Tommy Johnson said he's going to stand on his testimony in support. Yep. Next, we have testimony in support from the Hawaii Correctional System Oversight Commission.
The Commission supports this measure and respectfully requests the committee just be mindful that this proposal does not conflict with Chapter 614, which is entitled the Criminal Justice Research Institute. Thank you.
Thank you very much. Next, we have testimony and comments from the Legislative Reference Bureau. Testimony in support from the Department of the Prosecuting Attorney. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in strong support of the bill, and Chair, we thank you for hearing it. We do believe that this is a much-needed measure that would bring together all of the listed agencies to prepare and to plan for a renewed data repository that would have the capabilities of sharing information in real time, ensuring that the partnering agencies can share appropriate information. They're looking at the same definitions of information, as some of us might realize that one word, a terminology, might not always equate to the same terminology used by another agency, even if it's the same word per se. With regards to HIJUS, we absolutely appreciate and respect all the work that's been done in the past. We do understand that that system was initially built in 2009. We feel that it would be appropriate to have a new system, essentially, based on modern technology, modern platform. But we certainly welcome every opportunity to work with the AGs and their experience in this area. Thank you. Available for questions.
Thank you very much. And we have testimony in support from City and County of Honolulu, Michael Formby. Testimony with comments from Brian Black, Civil Beat Law Center for the Public Interest, and testimony in support from Jasper Clark Agosto. Is there anyone else here wishing to testify on House Bill 100? If not, questions, members. Representative Ganadin.
To the Oversight Commission, Ms. Tarney. Good afternoon.
Hi.
Hi. Memory serves me correctly. You and I both served on a task force about a decade ago discussing.
Yes, OHA.
Yeah, with Office of Hawaiian Affairs, discussing the overrepresentation of Native Hawaiians and Pacific Islanders.
And it's not the first one I sat on.
I know. That one had numerous individuals from the community discussing what kind of data we should be sharing. In reading HV 100, I'm reading on pages 3 and 4, 10 individuals, all from the government. Do you think it would be helpful to have some community input here so that we can try and map the trends of the justice system from the perspective of service providers, from those who are involved in it?
I have to say honestly that my understanding of this bill is to allow sharing of information between the law enforcement and prosecuting agencies to move their cases forward. So it has a different purpose than research. But that's my understanding. I'm not that familiar with what they're trying to propose.
Would this replace the HIJUS system that we were just discussing?
I couldn't answer that. I don't know.
I'm not sure if maybe the Office of the Attorney General could help me answer that question. Thank you. If that's all right, Chair.
Sure.
Okay. From the Office of the Attorney General.
Yes.
What is wrong with the HIJUS system, and why do we need to replace it with this criminal justice data sharing working group and the recommendations that they're going to provide?
Well, I don't think that anything's wrong with it. It's actually, the executive committee meets yearly. They vote on what initiatives, what they want to accomplish that year. And the heads of those agencies, they agree and they vote. It's for criminal justice information as far as arrest information. So bringing the public into that, there's a lot of information that cannot be shared with the public. So I think that question there is, it's more towards law enforcement, judiciary, probation, prosecutor's office, and it can be expanded to not only those entities, but also, as Aaron Harbinson was testifying on, including her as well as some other groups as well.
Would you also be discussing this information and data set with the federal government. So they're, in the last few decades, actually, there's been much discussion about data sharing with Homeland Security, with immigration, with the FBI.
Well, we share information, but we've never actually, as far as them wanting the information that we have, they have some access to that, through their systems, because we can communicate with our criminal justice information system, can communicate with the federal criminal justice information system. So you have CJIS and you have HIJIS. But as far as the data that is being shared, we do share that with multiple agencies, as well as has conducted research, and we provide that information to them as well. I don't know if I answered your
I understand.
question, but
Thank you.
yeah, yes, thank you.
Thank you, Representative Ganadin. Other questions, members? If not, I'd like to ask the prosecuting attorney to come up.
Yes,
So
Chair.
you've heard the testimony from others. They're saying, that the HIJIS system should be sufficient. In your testimony, you're saying, well, rather than me quoting it, if you could explain why you need this bill and this new working group instead of working within the existing system and maybe trying to improve that.
I can't say with 100% certainty that it's been entirely ruled out, not to base future work off of the HIJIS system. However, because the HIJIS system was created in 2009, it's based on, I believe, by technological standards, old technology. So using that as a foundation, the general thought is it wouldn't be as efficient. It would require a lot more workarounds, things that wouldn't be as difficult if you just started from new with modern current technology.
I must admit, I don't like to have duplicative programs that we're paying public money for. So the idea of creating a whole new system, I'm skeptical about. Could you explain how you've tried to work with the existing system? Have you made requests to the HIJIS Executive Committee to add the things that you think, or to, whether it's the data or the accessibility, have you done any of that?
I believe our department does participate in the HIJIS meetings, which apparently occur annually. But our department, and I suppose other departments, just feels that and again, I can't say with 100% certainty that's been entirely ruled out, but the needs of the departments are not, what we're looking to do is not met by the HIJIS system or by any of the upgrades that have been done to the HIJIS system, and it seems to just be a matter of technology, I think, at this point. Because imagine using a computer that you bought in 2009. It's just a really big computer.
Okay.
But same idea.
Okay, thank you very much.
Thank you.
Mr. Hignan? So you've heard the concerns from the prosecuting attorney and their desire for something that is more up to date, whether in the system. What has been your experience, and could you respond to that and help me out here? Can their needs be met within HIJIS? What has been attempted so far?
Well, our systems are not archaic. They're up to date as much as possible. But as I've learned from my staff, things change not by day, but by second as far as technology. So we make every effort to make sure our technology is up to date as far as the information. Yes, it was created well before I moved here, but it has progressed. We keep up with the technology. So I don't think that's the concern because of the technology being archaic, to be real honest. The data sharing is there. It's continuing as we speak. We're working with Hawaii County as well as prosecutor's office is sharing information. And I have to say that in the executive committee, who the heads of these departments all come and sit down, they all vote and agree on what the next initiative is. I kind of think, as I look at it, is maybe the Honolulu prosecutors, and this is just my thought, that they're trying to achieve this real-time data, which we are working towards. We understand that real-time data is very important, but I've also learned that it's just not as easy as flicking a switch. It takes some time. It takes creating these systems. So I understand the importance of them wanting real-time data, but there have been roadblocks within the agencies because one agency is in a cold freeze. So they can't participate in anything as far as helping initiate data sharing on their end. We've experienced that in the past as well. So I would respectfully have to disagree with the prosecutor's office saying that we're archaic and the information in our systems are old, because they are not. And I have to reiterate that it is duplicating, and HIJIS can be expanded.
Is the Honolulu prosecuting attorney representative on your board?
Yes, sir.
Okay.
Yes, sir.
And they've brought this up with you at their meetings, or is this bill a surprise? Did they discuss what's in this bill at your meetings?
This bill is a total surprise.
Okay.
We were not communicated with whatsoever. And so we're trying to scramble. We had one meeting, a 30-minute meeting with some of the IT people.
Okay.
And it caught us off guard. So the examples that were provided, I don't think were accurate.
Okay.
Yes, sir.
How often does your governing board, or whatever it's called, meet?
So the executive committee meets once a year, but then there's groups within that, technical groups, operational groups that meet. One of my staff who is assigned to the HIJIS program, he has operational technical meetings probably once every couple of months to see what the progress is as far as sharing the information.
Okay.
So it's just not a one-year meeting.
Okay.
It's continuous out throughout the year, sir.
Okay.
Yes, sir.
All right, well, thank you very much.
Thank you.
Members, any other questions? If not, we'll move on. Thanks very much to all the testifiers on that measure. Next, House Bill 1336, relating to criminal justice reform. It's a variety of different, there's a very long summary in here, but this is, I'll summarize it. I'll summarize the summary. It authorizes officers to issue citations in lieu of making certain arrests, authorize a 48-hour grace period for a missed initial court appearance, establishes a rebuttable presumption that a defendant is entitled to pretrial release, requires prosecution to prove that the release of the defendant would be inappropriate based on certain criteria, requires that the bail be set in an amount the defendant can afford under certain circumstances, prohibits the denial of pretrial release based solely upon certain factors, such as positive drug tests, requires automatic issuance of no contact orders in assaultive cases, requires the prosecution, when seeking to revoke pretrial release, to prove by preponderance of the evidence based on certain specified criteria, and requires the court to enter certain findings into the record. It also provides that a request that the defendant be ordered to undergo substance abuse assessment may be made anytime before trial, prohibits the arrest of a probationer or parolee, or the revocation of probation or parole solely due to the person having a positive drug test. First up, we have testimony in opposition from the judiciary. Next, we have testimony in opposition from the Attorney General. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas and members of the committee. Lauren Nakamura, I'm a Deputy Attorney General with the Department of the Attorney General. The department opposes the bill. First, because the data has shown as recently, we went over the numbers as recently as February 6, 2023, and they have demonstrated a significant decrease in pretrial detainee populations. And I will admit that they are still overpopulated, but the numbers have shown that drops include 13.8% to OCCC, 53.5% to HCCC, and 48.5% to MCCC. And we think those numbers could potentially drop further as time goes on. With respect to Part 1, the 48-hour grace period, allowing the defendant to have a sudden appearance without prior notice to the court places an undue burden not only on judicial staff but prosecution and defense counsel. As noted in the judiciary's testimony, this will especially affect our country courts that will have to extend days. Additionally, it would potentially allow defendants who pose a threat to public safety to remain in the community despite the fact that they have not appeared in court. The Part 1 allows the law enforcement officers to issue citations in lieu of arrest. First, we'd point out that these have now included felonies, and there are no limitations on which offenses cannot be issued citations in lieu of arrest. I would like to point out that the charges pointed out in our testimony are just C-level felonies that do not relate to physical assault and/or sexual assault. But as you can see, those charges can potentially endanger public safety. We note that the officer's judgment instead of judicial discretion is being used in these cases, and judges often are given more information than officers on the scene, and that information is incredibly important to preventing further risk to public safety. Additionally, they can potentially there are situations where citations may be issued to defendants who have already failed to appear on other cases. We would also note no framework has been stated in the bill regarding the initiation of felony cases. The problem with that potentially is that there is no judicial determination of probable cause. There's no review by prosecutors who could potentially even decline charges. And as such, there is an unintended effect on the accused because they are not given those opportunities for judicial or prosecutorial review. And also, we would note that by eliminating the risk of recidivism, which is problematic and not in line with the pretrial criminal task force recommendation number 1. With respect to the rebuttable presumption of release, the preponderance of the evidence burden is on the prosecution to establish no conditions for release are possible. Now, based on the language of the bill, it requires a release hearing, which would require prosecutors to produce witnesses and evidence. That could potentially include victims. And one of the national trends pointed out in the informational session was that there is an emphasis in national trend of bail reform for an emphasis on victim rights. And also, I would note that it places an undue burden on court staff, prosecution, and potentially defense counsel because those release hearings need to happen either at the bail hearing or initial appearance, whichever one happens first. With respect to the amendments to 804 7.1 that prevents denial of bail, despite it has been demonstrated that the defendant has not been able to follow an order by another judge to stay drug-free. It also prevents denial of bail when there has been a history by this particular defendant of non-appearance. And it also prevents denial of bail when release has previously been revoked in other cases. And also it prevents the court from considering convictions. It also prevents the court from considering arrests alongside of conviction. So essentially, in the end, contempts of court are typically issued whenever a defendant does not appear in court. Oftentimes, they're not charged and prosecuted pursuant to plea deal or something else by the prosecutor's office, and those charges are declined. The unintended effect of having this type of language in here is that it could potentially force prosecution to pursue such charges, which actually adds more charges to the defendant's case. Additionally, amendments...
If you could just, going forward, I know you've got much more to cover, if you could just try to give us the highlights.
Sure. Now, lastly, we would note that the amendments also require totality of the circumstances, yet they prevent the totality from the circumstances to be actually evaluated, such as non-appearance and also drug tests that also demonstrate a defendant's inability to comply with court orders. And lastly, I would note that with respect to Part 3, probationers and parolees have been adjudicated. There is no longer a presumption of innocence as to the original charges. As such, they have been ordered to remain drug-free as part of those conditions. And by taking away the drug language, the ability to revoke bail based on a single drug test, that also eliminates the case-by-case analysis that was stressed in the information session by eliminating the court and probation officers who participate in making what the most appropriate determination for that particular defendant is. Thank you. Available for questions.
Thank you very much. That was great summary of a very lengthy testimony, and I appreciate that. And I would ask my members to make sure that you have reviewed the testimony in detail. Next, we have testimony in support from the Office of the Public Defender. Welcome. The floor is yours. Please
Thank you.
proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa, and I appear on behalf of the Office of the Public Defender. It was mentioned in some of the testimony, several folks pointed out that there seems to be a typo in, I guess that would appear on, I just wanted to sort of confirm this before we go forward that.
It wasn't. Yeah. It was a typo.
Okay. Well, this morning I checked, well, first of all, the Office of the Public Defender supports HB 1336 HD1. I checked the numbers this morning. Unfortunately, new numbers were not posted on the on Public Safety's website. However, they have numbers that were current to February 20th, which was last week, Monday. At HCCC on the Big Island is at 140.3% capacity. Their operational capacity is 226. They currently have 317 inmates. On Maui at MCCC, they are currently at 106% capacity. Their operational capacity is 301, and they currently have 319 inmates. OCCC is currently at 111% capacity. And so that is 954, their operational capacity, and they currently have 1,059 inmates. I'm sure someone will correct me if I'm wrong, but the operational capacity is a number that is determined by the facility itself. I understand that they examine their space, their square footage, their resources, their staffing, and other factors, and they determine what that number is. So that number is what public safety is saying. This is what we can comfortably or competently and safely manage this number of inmates. So when we exceed that operational capacity, we're in dangerous waters. And what these numbers mean is that the state is being placed in a perilous position. It opens up the state to civil liability. It compromises the safety and security of the ACOs, or the prison guards, the civilian staff, visitors at the various facilities, and also the inmates. And finally, it also increases the risk of widespread or large-scale COVID outbreak. And so that's also a concern. HB 1336 HD1, I think, provides at least a partial answer to this problem, which has to be addressed, because the stark reality, given these numbers that I just rattled off, is that we cannot continue to cram human beings into these places without something really bad happening. Thank you for the opportunity to testify. I'll remain for questions. Thank you.
Thank you very much. And just for those who are watching when they were just listening about this typo, I'm referring to on page 4, line 18 of the bill, where it says the person poses a significant danger to a specific or reasonably, et cetera. It should have said the person poses no significant danger. So, and that has to do with if a police officer finds and is reasonably satisfied that the person is supposed to say poses no significant danger, then they'd be able to offer a citation instead of arrest. So that was a typo, but that will come in decision-making. We can talk about what we want to do to correct the current draft. Okay, let's go back to the testimony here. We have testimony with comments from the Department of Public Safety. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the community. I'm Frank Young, speaking on behalf of Director Johnson, Department of Public Safety. We stand on our written testimony offering comments on the bill, but to sum it up, we're looking at part 2 that limits revocations solely based on positive drug tests. We prefer that the discretion remain with the courts to assess on a case-by-case basis. I thank you for the opportunity to testify, and I'm available for questions.
Thank you very much.
you.
Next, we have testimony in opposition from the Hawaii Paroling Authority. Welcome, sir. The floor is yours. Please proceed.
Chair Tarnas, Vice Chair Takayama, members of the committee. The Hawaii Paroling Authority stands on this written testimony in strong opposition. We should note that bringing back to custody is a last resort with a positive or dirty UA. Sobriety is a lifelong challenge and a reason for regular drug testing. But we should also know that limiting HPA's response subverts parole officers' efforts to emphasize pro-social accountability while minimizing risk to the public for new offenses. I am available for questions.
Thank you. Next, we have testimony in support from the Hawaii Correctional System Oversight Commission.
The Commission supports the intent of this measure as it is consistent with the Commission's mandate to formulate policies and procedures to prevent the inmate population from exceeding the capacity of each correctional facility by potentially reducing the number of persons committed to jail pursuant to an arrest or failure to appear. We do defer to the judiciary and other law enforcement type agencies as to the details of this. We're not experts on that. I do want to clarify one thing, that the operational capacity was determined by the Corrections Population Management Commission, and our commission has now assumed their responsibility. It is based on standards. The current capacities were determined in 2001, and we need to revisit them, but it is based on national standards and other things taken into consideration. Thank you.
Thank you very much. Next, we have testimony in opposition from Mayor Mitch Roth, County of Hawaii, and testimony in opposition from the Hawaii County Office of the Prosecuting Attorney. Please proceed. We're not hearing you. There you are. Okay, please proceed, Keldon.
Aloha, Chair Tarnas, Vice Chair Takayama, and committee members, Hawaii County Prosecuting Attorney Keldon Walgen. We stand in opposition of this bill. I echo the same concerns as Deputy Attorney General Nakamura. Although the bill is well-intended, the consequences of the bill's overbreadth are concerning. We want to restore the public's trust and confidence in our criminal justice system. As a result, we believe that custody determination should be made by a judge on a case-by-case basis to ensure that public and victim safety concerns are properly considered. It is important to note that on Hawaii Island, it is not unusual that a large majority of the criminally accused are released on either supervised release or their own recognizance, or have bail reductions requests granted, oftentimes over prosecutors' objections. Judges oftentimes cite the conditions and the overcrowding concerns at HCCC as a justification when granting release requests. This is unacceptable. Jeopardizing public safety concerns simply on account of overcrowding and correctional facility conditions is misplaced and misguided. Those currently in custody on pretrial status oftentimes have several pending felony matters, have been previously granted supervised release and bail reductions over prosecutors' objections, and had their release status revoked based on the allegation of commission of new offenses. Prioritizing facility repair, the construction of new correctional facilities, and possibly relocating existing facilities is a better use of time and resources. I think it's important to note that HCCC, which is the main correctional facility on Hawaii Island, it's located just up the street from Hilo High School, Hilo Intermediate School, and Hilo Union School. Additionally, we support funding, staffing, and programs for supervision and reintegration services, and the prioritization of alternative forms of supervision where appropriate, such as electronic monitoring, which is very underutilized on our island, as a means to ease overcrowding, assist incarcerated persons while they reintegrate back into society, and reduce recidivism. At the beginning of this legislative season, our office conducted a legislative survey. A total of 674 persons participated. 77%, or 512 of the 674 who participated in the survey, indicated that they do not agree that defendants charged with nonviolent misdemeanor or felony offenses should be automatically released. I'd also like to acknowledge the concerns mentioned by Deputy Public Defender Hayakawa about the overcrowded nature of the facilities and its health and safety concerns to not only inmates but staff. My father worked at HCCC for nearly 35 years. He was an adult corrections officer. He retired as a lieutenant, and he retired during the pandemic. When he started in the 80s, HCCC was overcrowded. Since then, there's been population growth and little to no improvements.
Could you summarize, if you could summarize now, that'd be great.
Sure, Chair. Last month, I made the same statement, and I'll make it again. Hawaii Island is a big community, but we're a big island, but a small community. The people have made it clear they no longer feel safe in their homes and in their communities. That's not right. Let's work to address those concerns instead of increasing their fears. We submitted our written input, and I'm available to answer any other questions tomorrow.
Thank you very much. Next, we have testimony from Tricia Nakamatsu, Prosecuting Attorney, Honolulu.
Good afternoon again, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. The department is in opposition to the bill, though we do recognize and appreciate that great strides have been made to address many of the concerns that we and other agencies, perhaps individuals, mentioned during prior hearings. We would echo comments that were previously mentioned by other testifiers that we don't feel that overcrowding in and of itself should be a basis for changing procedures or protocol statutes simply which could also be at the risk of public safety. And that ultimately is our concern, is public safety and welfare, ensuring that things are done in a fair manner, but not at the risk of our community. We do feel that the court should maintain discretion to review cases on a case-by-case basis without blanket prohibitions or without blanket restrictions placed upon them. Many of the concerns that we noted in our written testimony were raised by prior testifiers, so I won't go at length on those, but I would want to emphasize sections 9, 10, 11, and 15 of the bill, which would prohibit the arrest of probationers or parolees for a single positive drug test or drug screening. We go into detail in our testimony about in particular, HOPE probation, which is a very specialized program within the judiciary, which relies specifically on this mechanism to bring HOPE probationers in on arrest if they test dirty, so to speak. This is not for the purpose of putting these people in jail. It's not even for the purpose of punishing them per se. It's used as a deterrent to encourage and motivate them and remind them that there are consequences and that they don't want to use, and that this provides the accountability system they might not have otherwise. Thank you.
Thank you very much. Next, we have testimony in opposition from the Hawaii Police Department. We also have testimony from the Honolulu Police Department with comments and in part in opposition. Next, we have testimony in opposition from the State of Hawaii Organization of Police Officers. Testimony in support from the Hawaii Health and Harm Reduction Center, Mr. Nikos Leverins. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. Nikos Leverins with Hawaii Health and Harm Reduction Center. You know, in recovery circles, one definition that's widely circulated of insanity is doing the same thing over and over again with the expectation of a different result. And what we've seen over decade after decade after decade after decade is that the continued criminalization of behavioral health problems, including substance use, has driven our jail and prison populations needlessly. We have a probation system with the highest average term in the nation by a good clip at 59 months. And it all begins with the dehumanization and the stigmatization of people who use substances. We see this very clearly in the testimony of the Hawaii Paroling Authority. Dirty, addict. This is not befitting professional organization. It's not befitting a policy that practices aloha, a polity that practices aloha. We also see this with the Honolulu Prosecutor's Office, who went on, the prosecutor himself was on KHON last week, basically equating drug use with child rape, and in almost the same sentence. He also forwards, Reagan Bush era rhetoric around cannabis use. So if we want to chart a different course in this state, and I think we do need to chart a different course in this state, we need to just say, "Not for ready," as my longshoreman grandfather used to say. End the biological dragnet and ensure that people are not placed back into jail or prison solely because they test positive for drugs, most probably cannabis. Mahalo for the opportunity to provide testimony.
Thank you very much. Next, we have testimony and support from Community Alliance on Prisons. Ms. Kat Brady, the floor is yours. Please proceed.
Aloha again. You know, substance use is a public health problem, and we've been trying for 50 years to make it a criminal legal problem, and it doesn't work. It's overcrowded our facilities, and it's wasted millions of dollars, sacrificed many, many lives, and it's all about the failed war on drugs. So to keep saying that the courts should figure out what somebody who is, using substances is ridiculous. They're not trained for that. So we definitely support this bill. We don't support the war on drugs, which has been devastating. You know, in America, every 25 seconds, somebody is arrested for drug possession. I mean, come on, what is going on? 1/5 of the incarcerated population is serving time for a drug offense. Incarcerating people for drug offenses has no effect on their substance use. And incarceration has a negligible effect on public safety. I included a link to a study that just came out in 2008, Ending the War on Drugs. And I also included a study that just came out in January talking about mass incarceration trends. And I put in a graph from the probation and parole portion of that. And, you know, parole and probation has expanded. And when you look at the graph, I mean, this is where we're going. This is insane. Hawaii does have the longest, as Mr. Leverance just referenced, 59 months for probation, the longest in the country, and that is what Pew found out. So we really need to rethink what we're doing, stop demonizing people, start treating substance use as a public health problem. It will have an amazing effect on our community if people think that you care about them. Thank you.
Thank you very much. Next, we have testimony in opposition from Jamie Detweiler, President, Hawaii Federation of Republican Women. Welcome. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. The Federation stands in strong opposition of HB 1336 HD1 for the following reasons. I have 3 areas of concern, but let me start off by mentioning these names. Please keep these names in mind. Mrs. Omura, Mrs. Christelle Tiauli, and Sarah Yara. We're going to be coming back to those names as I wrap up my testimony. But first of all, the first point I'd like to make is the rule of law. So let's talk about the rule of law. It's not made by mere discretion, right? And it's being treated fairly and equally. HB 1336 portrays the criminal as a victim. By lessening the consequences of their criminal action from an arrest to a citation, the bill gives criminals the power to reoffend and victimize law-abiding citizens. No consequence, no behavior change. Point number 2, our Hawaii State Constitution, Article 1, Section 5, speaks about due process. I'm all about due process for everyone. That includes those who commit the criminal offense, right? So I'm a firm believer in rehabilitation. You know, those people who are on drugs, you know, I acknowledge that, right? That is a serious issue, as testified by others before me. So rehabilitation needs to be brought into the picture as well. I support due process and equal protection for everyone, including alleged criminal defenders. Bill 1336 states that given Hawaii's high cost of living, many arrestees cannot afford to post bail, and that arrests are highly disruptive to a person's life. The majority of our citizens are law-abiding. They live paycheck to paycheck as well, and they're not committing crimes. The real victims here, as I started off with, those three individuals, were victims of recent crimes. Mrs. Omura, 77 years old, home broken into, encountered the person in there. He has a history of drug offenses. He also has a history of murder. Pushed her down the stairs. She incurred an orbital fracture, a cervical fracture, and a fractured arm, and required hospitalization. The second victim, Ms. Taliulu. She was the victim in the Walmart parking lot incident, and that individual who ran over with his car also has criminal history offenses. And the last person, Sarah Yara, 16-year-old, crossing in a crosswalk, was hit by a vehicle driven by somebody who had 164 citations. The citations did not stop him from doing what he did. These people all have grieving family members. So I'd like to stand on my testimony, and I urge you all to vote no for HB 1336. Thank you for the opportunity to testify. Aloha.
Thank you. Next, we have testimony in support from ACLU Hawaii.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. My name is Wookie Kim. I'm the legal director of the ACLU Hawaii. Our organization supports this bill, although we do believe that the original version was better than the HD one. That said, this bill is important because it takes steps to reverse three very harmful norms in our criminal legal system. First, this bill addresses the knee-jerk reflex of having law enforcement officials detain and restrain people accused of crimes through custodial arrests. Our organization has seen the deep harm that can be caused by such arrests, not just to those who are arrested, but also their families and communities. And so by modifying law enforcement's discretion to use citation in lieu of arrest, this bill reduces those harms and ultimately makes our community safer. Second, this bill reverses the devastating practice within our pretrial system of forcing people in poverty who are accused of crimes to prove that they should not be locked in a jail cell before trial. But that's not how our system should be. As the Supreme Court has stated, quote, in our society, liberty is the norm and pretrial detention is a carefully limited exception. This bill breathes life into that constitutional principle by presuming that people accused of crimes should be free pretrial. And it correctly puts the burden on the prosecution to prove that one's liberty must be taken away. Third, this bill reverses the automatic impulse to punish and incarcerate our way out of substance use disorders. This bill correctly rewires that impulse to instead provide treatment and rehabilitation to this vulnerable group. And so for these reasons, and those stated in our written testimony, the ACLU of Hawaii supports this bill. Thank you.
Thank you very much. And next we have testimony in support from Ho'opono na Mea Ola, Ilima DaCosta. Testimony in support from Hawaii Alliance for Progressive Action, Ann Frederick. Testimony in opposition from Michael Kitchens with Stolen Stuff Hawaii. Testimony in opposition from American Bail Coalition, Jeff Clayton. Testimony in opposition from Rita Kamakimura. Testimony in opposition from Gerard Silva, John Deutzman, Daniel Meredith, Mary Smart, Beverly Heiser, Keli'i Buen Consejo, Kim Koyanagi, Keke Manera, and testimony in support from Dana Kiave, Thaddeus Pham, Esther Giel, Will Karen, Nanea Lowe, Diana Bethel, Shannon Rudolph, Michael Paul. Testimony in opposition from Donna Van Ostel. Testimony in support from Emily Sarasa. Testimony in opposition from the following individuals: Jamie Barboza, Michael Rice, Janelle Garcia, Mona Kidd, Jessica Tamari Bucci, and Garner Shimizu. Is there anyone else here wishing to testify on HB 1336? If not, questions, members? Yes. Representative Holt, please proceed.
For the public defender, please. Thank you very much, and apologize for my ignorance, but just for some background, how many cases does a public defender have in 48 hours? Are you guys currently understaffed, or how's your guys' caseload?
Gosh, I think it might depend who you ask. I think for the most part, especially coming back after the pandemic, courts are getting back, trials are happening. Caseloads are pretty heavy right now. I can't tell you how many cases come in a 48-hour period, though.
So by passing a measure like this with the 48-hour grace period, I'd imagine that would make your office tie defenders up more than they currently are?
So the bill isn't completely clear on sort of the process. People have pointed out that, that it would require the courts to stay open and sort of have the courtroom have personnel there at all times. And so I feel like the public defenders would accommodate, if it had to do with a client avoiding a bench warrant, we'd pretty much do whatever it took.
So you guys would just have to stay on call and wait?
Yeah, which we do in a couple other areas as well, so.
Okay, thanks. And what about the judiciary's concerns about the rural courts who only operate once a week? How would we give them the 48 hours?
Right. I mean, the judiciary makes a fair point. I'm not sure how that would happen, but I am aware that whether it's here or the neighbor islands, the outer rural courts only are open several days a week.
And so, practically, what would happen if somebody came back in 47 hours and 59 minutes and didn't get their court appearance? What would happen after the clock strikes 48 hours?
Yeah, no, I don't know.
Okay.
I mean, I'm sorry. I mean, the bench warrant would probably issue, and then that person would then have to contact
So
an
at least
attorney.
he's there, though. You could get him because he's already brought himself in. So you put the bench warrant on the guy after.
Right. That could happen, yes.
I also had another question, if that's okay, Chair.
Certainly.
The bill says, sorry, let me pull it up real quick. If the individual does not pose a significant danger, specific or reasonable identifiable person or persons, based upon an articulable risk to a specific person, as evidenced by the circumstance of the offense. Now, could you tell me when breaking one of these violations, you would think it would be okay if it was a violation of privacy, harassment from stalking, impersonating an officer, or terroristic threatening? Would there be cases where you would think that that would be okay to give a ticket?
I think it would be very unusual, to be honest. I mean, I envision a scenario where maybe an officer responds to a call, maybe there's neighbors fighting, and he does find a suspect that's accused of perhaps misdemeanor assault. I wouldn't blame the officer in that situation. If things were still heated, there was still some hostility that, to take that person in and physically arrest them.
Okay, to me, it seems like those types of offenses are directly against what it says in the statute. But what is the real need for this measure? You're one of the few people in support. Is there a real need for us? I understand, aside from the overcrowding, is there a need for us to pass this measure? Because I would side with some of the members of our community saying that they feel unsafe at the moment and saying that crime is going in the wrong direction. And I think this sends a wrong message to our community. So how would you address that?
Thank you for that question. So I rattled off numbers regarding overcrowding, and it wasn't just for the heck of it. The reason that I bring up those numbers is if we go back to, I think it was 1984 or 1985, the ACLU sued the state of Hawaii prison system, alleging overcrowding, bad conditions, etc. This was entertained by the federal government. And so what concerns me is that If this happens again, the federal government is going to come in and they're going to tell the state correctional system how to do their job. And these people are going to get released and they're going to be able to make the rules. I'd like to see the state get ahead of this and figure out some criteria, because there will be a point in time where we're going to have to prioritize who should be in jail and who shouldn't. And if you have to make the decision between a violent offender being in jail as opposed to a property offender, I feel like 9 times out of 10 or more, people are going to say, I'd rather have that violent offender in custody. So that's why we're having this distinction between property offenses, non-violent offenses, and of course, violent offenses.
So my last question, if it seems like we're kind of putting a blanket over some of these felonies, if we're looking at not arresting some of these offenses, do you think it'd be better for us to go offense by offense and maybe knock them down to misdemeanors instead of passing a bill such as this?
Gosh, I'm not sure how to answer that question.
Thank you. Thank you, Chair.
Thank you very much. Other questions, members? Representative Ganadin.
The intention of this bill isn't some sort of big bleeding heart measure. We're trying to basically codify best practices that's happening nationwide, and some of the lessons that we've learned from COVID and from drug court, veterans court, things like that. What usually happens when someone makes an honest mistake and misses a court date and the court just puts in the minutes a continuance for 2 days?
When someone misses a court date and we don't have the benefit of this 48-hour grace period?
Yes.
Well, hopefully they can contact an attorney or the public defender's office. And even if we're not already representing that individual, they are welcome to come in, fill out an application, and we will take care of something called, or we will file something called a motion to recall the bench warrant. It depends when it's scheduled. They can be scheduled pretty quickly that week, or a few weeks down the line. We have to sort of instruct our client to kind of lay low because there's a live bench warrant out for you. Once we get a hearing date, then it's calendared. We appear before the court. There's a prosecutor.
Yeah. So there's other states that are doing things like reminding individuals who are charged with driving without a license, driving without insurance, petty misdemeanors and misdemeanors that they have a forthcoming court date. Is that happening here in the state of Hawaii? Are we reminding people that they have court for minor nonviolent offenses?
As I understand it, the system is in place, but it's limited. And I think there's a bill, and Mr. Tabe actually has written on that particular bill. But we are urging for it to be more widespread, to remind folks of their court dates.
So ordinarily, a court can just make a continuance, put it in the record, and then hear the case a few days down the line.
Right. Another thing that defense attorneys will do is ask the court to hold the bench warrant in abeyance, and with the courts, I guess, with their indulgence, they'll put it a couple days down the line, and we'll urge them. I need a chance to get in touch with my client. I'm pretty sure I can bring him in, and sometimes that's done as well.
Thank you. Regarding the citation in lieu of arrest, there's just on KHON2, the chief of police sounds like he was in support of this. What kind of policies were in place by HPD, to your knowledge, in giving individuals citations for petty misdemeanors? I mean, like treating many things that were like petty misdemeanors and misdemeanors like traffic offenses to decrease interactions with the courts.
It's a little bit hit or miss. Mr. Tabe actually was just reminding me of during COVID, during the pandemic, officers were urged to give people a warning before giving them a ticket on like a mask violation. And so the HPD officers, I think they did pretty well there. And so we did hear about more warnings, less tickets. And so the officers, I think, are used to exercising that sort of discretion.
Okay. One more, Chair. There's been much discussion about drug use as basically a human behavior, like with what we know about the way addiction works now after decades of research and study. Is it common practice in drug court and Veterans Court, these are specialty courts, to arrest an individual after a sole positive test?
So you're talking about, there's drug court, there's mental health court, there's veterans court.
That's right. There's a lot of specialty courts which are aimed at, I guess what we could call judicial best practices in trying to assist individuals with mental health or addiction issues, and then their entanglement with the justice system. So what usually happens?
So to be honest, I'm a little bit removed from those specialty courts, so I don't know what happens on a day-to-day basis.
Okay.
I think they have they do have the discretion to pull in a person based on on a sole drug, dirty UA.
Okay, thank you. Maybe I could direct that to the Office of the Attorney General.
Okay.
Okay. Thank you, Mr. Echo.
You want to repeat your question,
Yeah.
Representative Gannon?
Yeah, good afternoon. Thank you for your earlier testimony. There's nobody here from the judiciary, I don't believe. Okay, so I'm going to direct it to the Office of the Attorney General. What ordinarily happens to individuals who test positive in these specialty courts? Are they offered treatment? Are they offered, are they immediately arrested? What happens?
Again, I am not as familiar with all of the specialty courts. I do know, I did have a little bit of experience with Hope Probation in 2011 through 2012. In situations like that, the Hope probationer was given a Hope warning, which walks them through exactly what the expectations are of the Hope probation program, and tells them very specifically, the first time you test dirty, you will go to jail for a certain amount of time. If the second time you do it, and the number increases per times you test dirty. And that is with the understanding that they are expected to remain drug-free throughout the term of Hope probation. Additionally, during that time, the public defender and the prosecution was working together to get these people into substance abuse programs to address their addiction issue. The purpose of the jail sentencing was only to the extent that it would be a deterrent. When it comes to longer jail sentences, the court was aware of the significant impact it would have on a defendant's lifestyle, for example, his job. And that's why Hope Probation was allowing defendants to report only on weekends, so they were able to keep their job. It did place a burden on our prison systems, however, it was made to work to a certain extent. And that's why, but with respect to the other specialty courts, I can't speak with any particular knowledge.
Okay. Would you say that it's, we're not, the judiciary isn't really pursuing Hope Probation right now, and this committee has not supported its expansion. So would you say that it's best practices to no longer arrest an individual for a sole positive testing for drug use, because it seems like this is just the general practice now in these specialty courts to continue to support them getting treatment in lieu of arrest?
Respectfully, I would have to disagree, particularly in situations involving bail, probation, and parole. Part of the reason why the court sets conditions on those particular individuals is because they have, especially in the sense of probation and parole, they have been adjudicated, and they have to follow the rules of law just like other citizens. And they have an additional burden because they have been adjudicated to maintain certain conditions of lifestyle that are meant to help them recover and re-engage back into society. So regardless of whether it is a single UA or something else, the inability to follow those conditions, which are based upon the judge's discretion, and believes that those conditions will not only address the defendant's need, but also address public safety at the same time. An inability to follow those conditions does pose a problem.
One more? Okay.
Was the Office of the Attorney General part of the task force that discussed pretrial best practices 5 years ago?
Yes, we were.
were you in agreement? Was it, how did the task force come to the suggestion that the burden of proof should shift to the state when arguing that an individual should remain in custody pretrial?
So I was not a member of the criminal pretrial task force. However, it is my understanding that the Attorney General did participate, someone from the Attorney General's office did participate. And also, please, I remember also, I was told that the pretrial criminal task force report was recommendations that were not necessarily unanimously agreed on by all members of the task force. A lot of the recommendations that are particularly mentioned in the bill were opposed by the member that came from the Criminal Justice Division of the Attorney General's office.
But again, that task force was headed by the Honorable Ram Trader, who's now a federal court judge, as well as about a dozen individuals from across the spectrum of the criminal justice system. Is that correct?
I would have to trust your opinion on that.
Thank you.
Thank you.
Okay, thank you. Representative Takayama?
Oh, go ahead.
Oh, Representative Souza, you go next.
Just a quick question for the Oversight Commission, please. Thank you.
Hi.
Hi. So the commission supports the intent of this bill to adhere to its mandate, which is to establish maximum inmate population limits for each correctional facility and formulate policies and procedures to prevent the inmate population from exceeding the capacity of each correctional facility. Can you explain to us, aside from what this bill's intent, is going to do to limit the population, what other policies and procedures are you guys considering or currently are looking at to reduce the inmate population?
We're not quite at that point yet, because we
Okay.
really only had staff for the last 6 months. We've been meeting, though, for 3.5 years. But it will be the range from sentencing, making recommendations about sentencing, about pretrial populations, about probation and parole revocations. It will be the whole gamut when we get to that point.
Okay, thank you so much.
Thank you.
Thank you. Representative Takayama.
A question for paroling authority, Mr. Hune. Mr. Hune, you made reference in your testimony to drug testing by the parole board. What do you test for? Do you test for all illegal drugs?
Well, just one correction. The parole officers do regular testing, and depends on the level of supervision of any other parolees. But generally, it's a 5 or 6 panel test that will test a range from marijuana through ice and fentanyl.
Okay. So in your practice, would a single drug test for positive drug test for, say, marijuana be grounds to revoke parole?
No.
What would be grounds?
Generally, okay, so when I was involved in parole revocations hearing today. We have about 20 revocation hearings tomorrow. So when a warrant goes out, it could be for one positive drug test, but when you look at the history, there could have been several drug tests which all turned out positive for cocaine, heroin, ice mainly. And although those are individual instances, a lot of them will be referred for drug treatment, outpatient type services, and they may complete it or they may not complete it. So like today, we had 5 drug tests, dirties, pardon the expression to one of our speakers. But at each one of those times, that individual wasn't revoked. And then when they violated curfew and had another drug test that came out dirty, the warrant went out for retake, which is a no bail warrant. Person was brought back for a revocation hearing, and then we saw him today, within 60 days of his retake.
So you're saying it's highly unusual for a single drug test, whether it be marijuana or crystal meth, to be
Very
grounds
unusual.
for revocation. Okay, thank you, Chair.
Thank you. Any other questions, members? Yep, second time around, Representative Holt.
Public defenders, please. Just regarding the 48-hour grace period, I'm just wondering who decides whether it was an honest mistake, and how do they make that just decision?
The way I read the bill, I don't think it sounds like there's sort of like a no questions asked policy where you just show up and you get back on track.
So that's where I was getting to. You guys are, in your testimony, referring to especially individuals who missed for honest mistake or emergency, but I mean, these are people who have already most likely committed crimes. So, I mean, to try to give them the benefit of an honest mistake is a little bit misleading.
Yeah, well, I mean, to be honest, I mean, we see everything on the spectrum. I mean, we have wayward clients that they just don't make their court. There's those guys, but certainly there's a number of mostly law-abiding citizens that, again, you know, life happens and things happen, and that I do believe that they simply forgot or they miscalendared it, or a lot of things can go wrong.
And would you be in support of a 96-hour window instead? 128?
I suppose thank you.
Thank you very much. Any other questions, members? If not, let's move on to the next. Let's go on to the next measure. Thank you very much for everyone testifying on that. It's 1336 is a very important measure. It's asking for a paradigm shift, and that's not comfortable for anybody. And so it certainly engenders a lot of strong feelings. So I appreciate everyone bringing in their perspectives on this measure. It's important that we hear that. Okay, let's move on to House Bill 125 relating to criminal procedure. Adds a new section to the statutes establishing circumstances in which the presence of a defendant is required for court proceedings or may be waived. First up, we have testimony with comments from the Department of Public Safety.
Excuse me. Hello, Chair Tarnas, Vice Chair Takayama, members of the committee, Michael Hoffman, presently the Acting Deputy Director for Corrections. Department of Public Safety offers only comments on House Bill 125, which proposes the established circumstances in which the presence of a defendant is required for court proceedings. We carry the responsibility of transporting the inmates to court for their appearances, and also when allowed, we have to make sure they appear via video conferencing. As the Hawaii Rules of Penal Procedure already set standards for the presence of the defendant under Rule 43, PSD defers to the decision of the courts, but we believe codifying procedures for the defendant's presence restricts judicial discretion and may prohibit the court's ability to amend rules should new circumstances present themselves, such as the recent COVID-19 pandemic. PSD appreciates the ability, and I want to emphasize, we really do appreciate the ability to utilize video conferencing whenever possible, as it provides a safe and economical alternative while ensuring meaningful access to the courts. Allowing the courts to have flexibility encourages new innovations to reduce the impact of having to physically transport inmates for their court appearances, and I certainly believe it also lends to community safety. So thank you for allowing us to testify and give comments on HB 125, and I'll be present for questions if you have any.
Thank you very much. Next, we have testimony in opposition from the Office of the Public Defender. Welcome. Please proceed.
Welcome. Good afternoon, Chair Tarnas, members of the committee. I'm James Tabe. I'm the State Public Defender. Our office does oppose this bill. First off, basically, it's just not necessary. Procedures dealing with presence of the defendant or waiver of presence of defendant is already controlled by Rule 43, which of the Hawaii Rules of Penal Procedure, as the previous testifier mentioned. It's basically, those rules have the force of law. It's made up, the rules are drafted and monitored by the Standing Committee on Rules of Penal Procedure. They consist of the judiciary, prosecuting agencies, our office, and members of the criminal defense bar. So it's just completely not necessary. Now, if the committee intends to pass this measure, we do have a strong objection to subsection 6, where they have this mandatory waiver after 2 non-court appearances. First of all, the rule is not necessary, and I'm going to have to amend our testimony, is that the judges already have discretion to waive their appearance of a defendant if they keep on not showing up. If they think they're doing it on purpose or there's no good reason for it. Its case law supports it. It comes back, it's Matthias v. State. Back in 1992, the case was decided, and that's been a standing case. And judges have used that case to say, look, defendant's not showing up, we're proceeding without him or her. So again, it's not necessary. Another part of the problem with the subsection 6 is that it's requiring the defense attorney to provide copies to the defendant. Now, the problem with this, my office, we always do that, one way or the other, in person, by mail, or whatnot. But many of the defendants at arraignment, they don't have attorneys, so there's no one really to provide them with the copy, because they have to qualify for our services. If they don't appear in court, we can't represent them until we qualify them. And so there's a problem to that requirement as well. So we just ask that the bill be deferred, because again, it's not necessary. The Committee on Penal Rules can handle this. Thank you.
Thank you very much. And final testimony in support from the Department of the Prosecuting Attorney, City and County of Honolulu. Welcome. The floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in strong support of this bill. This bill is part of our 2023 legislative package, and we thank you, Chair, for hearing it. This bill stems from a relatively straightforward problem in that we've had instances where the prosecution was not able to proceed for multiple hearings simply because a defendant who was in custody at OCCC, or defendants, refused to come out of their cell. And we understand that there are mechanisms that the court could order the defendant be brought there, that PSD does have some sort of a wrap or something that could be done to actually bring somebody there who, for lack of a better term, against their will, because they are ordered to appear in court. But that simply hasn't been done. I'm sure for various policy reasons, and I'm sure we wouldn't necessarily, I'm sure PSD doesn't want to be put in that situation to have to force somebody out of their cell. But the fact remains that it has been a problem. We've heard of at least one deputy said 6 times they had to come back to court because the defendant simply refused to come out. And it just continues on that way. It's a waste of resources, it's a waste of time for everyone involved. Even though video conferencing is available as an option, there are defendants who refuse to come out of their cell for video conferencing. So we feel that the bill provides reasonable mechanisms to provide notice, especially if it's for arraignment, a copy of their charge that would ensure that their rights are being protected, but also ensuring that the process is able to go on without them if they simply refuse to show. Thank you. We're available for questions, if any.
Thank you very much. Is there anyone else here wishing to testify on House Bill 125? If not, questions, members? May I have the prosecuting attorney back up briefly? I just wanted to ask, have you brought this up with the Rule 43, or with the Rules of Penal Procedure Committee in regards to potentially amending Rule 43 to address your concern? Have you brought that up?
I don't know. I can't say for sure.
Not sure. Okay.
Sorry.
Okay, thank you. Any other questions, members? If not, let's go on. Thanks very much to the testifiers on that measure. Next, we have our first Senate bill that we're going to hear. Senate Bill 36, relating to the initiation of felony prosecutions, specifies that a person may be tried and sentenced for certain alleged felony offenses through the complaint and preliminary hearing process, indictment by grand jury, or by written information. Specifies that multiple attempts to initiate a felony prosecution for the same offense, either through the same initial charging method or an alternative method, or in different forums, shall not be permitted, except in certain circumstances. First up, we have testimony with comments, testimony in support from the Attorney General. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, members of the committee. Amy Murakami for the Department of the Attorney General. This bill amends HRS Section 801-1 to permit criminal prosecutions to be initiated in the circuit court by complaint, and also places limitations on the prosecution's ability to initiate charges after a finding of no bail from a grand jury or no probable cause by a judge at a preliminary hearing. This bill is very important because the preliminary hearings are in the essential part of the criminal justice system. It benefits the administration of justice, the prosecution, the defendant, and in particular witnesses and victims who, if without this, may have to go to 2 hearings for the initiation of criminal charges. Preliminary hearings are a reasonable and expeditious way of initiating charges against defendants who are arrested and are in custody pending charges. For these reasons, the department asks this committee to pass this bill unamended. Thank you.
Thank you very much. Next, we have testimony with comments from the Office of the Public Defender. Welcome. Please proceed.
James Taber, State Public Defender. We actually support most of this bill here. We support the provision that allows the prosecutor's office to initiate proceedings for a preliminary hearing. We do agree with the Attorney General and with the prosecutor. It is an efficient way of initiating a case. We also support the codification of Justice Nakayama's concurrence in State v. Obrero, which allows the prosecution a second attempt if they had a rejection or a no bail, if there's new evidence that they discovered. Our objection to this bill, though, is what Justice Nakayama did not include in her concurring opinion, and it's the 2 additional exceptions that this bill has. One is the good cause exception, and the other one is the grand jury misconduct or grand jury counsel exception. First of all, the good cause exception is too broad. We think it can be misused. It probably would be litigated in the appellate courts if this happened. It's especially, we're afraid that a judge on a very heinous crime will just say, oh, that crime was so, facts seem so bad, we'll just give you another shot at it. Whether that's good cause or not, whether it stands, it would have to be litigated. As for the grand jury misconduct exception, this is when they have to start digging in. I don't know how they're going to find misconduct, especially when they're not allowed to question grand jurors or even, just regular jurors, the reason why they voted one way or the other. So that poses a very difficult problem. And we do have posed a requirement. I do understand that this bill cleared the Senate floor already, so amending it would be quite difficult, so to speak. But we did propose a notice requirement because there's many times where we did not know or we found out by accident that, you went through this was your second grand jury on this case. So we would like to know that. We proposed some language. Obviously, we're not professional bill writers, so I don't feel free to amend. Other than that, I am, let's see, before I leave here, I heard the bell. Other than that, yeah, I'm available for questions. Thank you very much.
Thank you very much.
Actually, one thing, I just want to thank the staff because we submitted the wrong testimony and they were able to replace it, and I thank you very much to your staff.
Absolutely. I've got the best staff in this house. Thank you very much. Okay, next we have testimony and support from the Department of Prosecuting Attorney. I think we have Mr. Allen on Zoom. Please proceed.
Oh, thank you. Chair Tarnas, Vice Chair Takayama, members of the committee, we do stand in strong support to it. And we want to thank first the Senate and now the House for dealing with this expeditiously because we do want to go back to preliminary hearings. That has been the law of the land for 40 years after the Constitutional Convention, being able to choose between grand jury and preliminary hearing. And we still have a backlog of cases we'd like to get through. So we thank you for doing that. And dealing with it right away. We worked with the defense and Senator Rhodes for months in the off season, going back and forth. I don't think either side was completely happy with it, but we all agreed we can live with this. So this is what came out of it. and we're in support of the bill. So thank you very much. I'm available for questions.
Thank you very much. And next we have testimony and support from the Honolulu Police. Welcome. The floor is yours. Please proceed.
Aloha Chair, Vice Chair, committee members. Captain Andre Peters of the Honolulu Police Department's Criminal Investigation Division. We stand in strong support and on our written testimony, mostly based on the prosecutor's package. I'll be available for any questions.
Thank you very much. And we have testimony and support from Hawaii County Office of the Prosecuting Attorney. Mr. Walchin, please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, committee members, Hawaii County Prosecuting Attorney Kelvin Walgen. Mahalo for hearing SB 36 so quickly. SB 36 is important to police, prosecutors, law enforcement, community safety, and our criminal justice system. And that includes victims and the rights of the criminally accused. As noted by Senate Judiciary Chair Rhodes in the Senate Committee report, SB 36 is a compromise, but it is the result of a months-long dialogue between the interested parties, the 4 county prosecutors, the Attorney General, and the public defenders. SB 36 is consistent with the intent of the Hawaii Constitution, restores criminal procedures and practices that have been in place for the last 40 years, supports and protects victims and witnesses of crimes, affords the criminally accused an opportunity to participate in the felony initiation of a felony criminal case, and it provides law enforcement with the resources necessary to ensure public safety. But it also creates additional safeguards against unjustified multiple attempts to initiate a felony criminal case by prosecutors. Restoring prosecutors' authority to initiate felony prosecutions by way of the complaint and preliminary hearing process is necessary, and it restores the public's trust and confidence in our criminal justice system. We stand in support of this bill. We ask that the committee pass this bill unamended. I'm available to answer any questions that you may have. Mahalo.
Thank you very much. Next we have testimony and support from Mayor Mitch Roth, County of Hawaii, Rebecca Leake from County of Kauai, Office of the Prosecuting Attorney, County of Maui, Department of the Prosecuting Attorney, the Waikiki Neighborhood Board, and from Victor Ramos. Is there anyone else wishing to testify on Senate Bill 36? If not, questions, members. Representative Ganadin.
To Mr. Walchin, the Hawaii County Prosecutor. I believe he was just there.
Yep, sir.
Yeah. Thank you for your service. We heard earlier in another bill that discussed revisiting the issues brought up by the Abrero case from the Office of the Prosecutor here in Honolulu, that despite an initial scare that individuals would be released as a result of that decision, that in fact no individuals were released pending their A or B felony charges. What happened there on Hawaii Island?
There was a few cases that were dismissed pursuant to Obrero arguments. We did have to make decisions whether or not those cases were initiated to be recharged. We did recharge some of those cases. It was a small number. One of the things that we had to do was we had to work between the limitations of the judiciary at the time. On Hawaii Island, we only had 2 opportunities for grand jury sessions on the east side of the island and only 1 opportunity for grand jury session on the west side of the island. We worked with the judiciary and we were able to secure in this calendar year 4 grand jury opportunities per month on each side of the island to help us navigate this situation of not having preliminary hearings. There's been situations where we had very serious cases charged. There was a kidnapping, sexual assault case. We had attempted murder cases, robberies, where we had to present a district court preliminary hearing on one side of the island, and at the very same time, a deputy prosecuting attorney was on the other side of the island presenting the same case before a grand jury in order to ensure that the serious offender, what we deemed to be a serious offender, was not prematurely released. But we were able to get it done, in working with the men and women of the Hawaii County Police Department, as well as our victim advocates, and working with the judiciary. So I feel like we were able to get things done and avoid any any serious offenders being released from custody.
Okay.
The biggest concern for Hawaii Island was that because there was a gap, and between December, the last week of December and the third week in January, we did not have a grand jury impaneled. We impaneled a grand jury the first week in January, but that first grand jury wasn't scheduled to show up until the third week in January. As a result, there was approximately a 3-week gap that was very concerning. If a serious case were to come in, whether it be a sexual assault, kidnapping, a murder, robbery in the first degree, there was concerns that an individual could be charged in district court. We would conduct a preliminary hearing, and then that individual would be, if probable cause was determined, it would be ordered to appear in circuit court. If that initial appearance were to be set up before we were able to impanel and present the case before a grand jury, there was a chance that individual could be relieved.
Okay, I got one more.
Thank you. Yes, one more.
Page 4, line 13 discusses the court, upon application of the prosecutor, finds good cause to allow subsequent presentation. Of course, the Office of the Public Defender believed that this might not be constitutional, and that this is likely going up to the Hawaii Supreme Court if we pass it as written. What do you think good cause is?
I'm of the belief that the situations in which we're going to be coming before the court and asking for leave to present a case subsequently is going to be few and far in between. There might be a situation where we have to proceed to preliminary hearing absent a victim being a necessary witness that we would normally utilize and present that witness's testimony in district court, and let's say, or at a grand jury proceeding, and if that witness wasn't available, there might be another situation where maybe additional evidence becomes available and known to the state after the initial presentation. So that's what I believe that would be.
Do you think that you should just wait until you have the evidence to charge appropriately?
Unfortunately, we don't have that luxury in all situations. Public safety is a concern. If a crime is committed, as much as we want to go to and present a case with all the facts and circumstances that we can possibly have at that time, we don't know what we're going to have. There might be more facts and circumstances that become available to us after a case is charged, but we also have to seek justice for the victim and ensure that public safety is ensured. And if we believe that we can present a case and we have probable cause to charge someone, we look at a case and we try to charge a case based on whether or not we think we can prove a case beyond a reasonable doubt. That's the standard that we use. So unfortunately, sometimes facts and circumstances become available to us after a case is already charged. And sometimes that turns into a situation where we may have to ultimately make a decision where maybe a charge gets dismissed. It may be in the interest of the defendant.
Okay, got it.
I hope that
Thank
answers
you.
your question.
Thank you.
Thank you very much. Any other questions, members? If not, let's move on. With the members' forbearance, I'd like to take one of the measures out of order. I've got several testifiers here on House Bill 1134. I'm sure they would like to move along, do other things. So with your forbearance, I'd like to do that. House Bill 1134 relating to Kaneohe Bay prohibits commercial ocean use activity in Kaneohe Bay waters without a permit, prohibits any person from advertising any commercial ocean use activity in Kaneohe Bay waters for which the person does not have a permit, lease, or license. So on this measure, first up, we would have Department of Land and Natural Resources.
Aloha Chair, Vice Chair, members of the committee, Laura Ka'akua with DLNR. The department stands on our testimony providing comments. I did want to point out that we absolutely understand the community sentiment that wants to have more regulation for Kaneohe Bay deservingly. And we just wanted to highlight that in order to do that, we really do need more folks on the ground. And I know we mentioned in our testimony here that we would need increased staffing, and expecting a possible question on that, I will just share that really Kaneohe Bay is so massive that to have enough staff present that we could spot when buses are pulling out to unload kayaks and activities of that sort. We would need approximately 3 dole care agents, likely 2 in the water and 1 on land, and a dole bore staff person or a division of boating and ocean recreation staff person to be that on-site educator. And with those resources, then we could support this, but we just want to also be realistic about the department's capacity. So if there's a change in the law, we support the intent, but would need the resources to actually implement. Mahalo.
Thank you very much. Next, we have testimony and support from Lealoha Rocky Kaluhiva. Auntie, I was looking at you and I was thinking, I better move this up. Please proceed.
Mahalo, I appreciate that. Aloha, mahalo, Chair Tarnas, Co-Chair Takayama, and members of the committee. My name is Lealoha Rocky Kaluhiva, and mahalo again for hearing us. I'm speaking in favor of House Bill 1134. Due to the fact, I'll give you just a short, brief history of this, why we made this bill. Hopefully it'll pass. Kaneohe Bay is made up of 9 of the 11 ahapua'a of the Kola Pokomoku. I live in the Heia ahapua'a, right on the shoreline of Kaneohe Bay. In the late 1980s, we saw the commercial businesses getting more and more into our bay. So we decided we have to put some kind of rules and regulations into this bay. So by 1990, we came across with Act 208, which is a law put together by over 100 community members from every one of the ahapua'a in Kaneohe Bay, including the Department of Land and Natural Resources, the Kaneohe Bay Marine Corps Air Station, the Hawaii Institute of Marine Biology. So we thought we had it down pat to get the rules done. But then we had to form a committee with the help of the state. The committee consists of a person from the commercial business, one from the Kahalua Neighborhood Board, one from the Kaneohe Neighborhood Board, one from the recreational fishing group, one from the recreational boaters, and one from the commercial business groups, and the HIB, the Hawaii Institute of Marine Biology, the Kaneohe Marine Base. So this is the Kaneohe Bay Regional Council, and this committee has to be recommended by the community and by the governor and sanctioned by the legislature. So they have these rules, and one of the rules is no commercial businesses can be commercialized in Kaneohe Bay without a permit from the Department of Land and Natural Resources. It was a negotiable thing that the community and the commercial businesses finally negotiated that they cannot use the commercial businesses on Sundays or 3-day weekends. We later had that amended in the late 1990s to no drinking on federal 3-day holidays because they started to have riots and over excessive drinking, and so that was amended. Also, you needed a permit, and if you don't have a permit, you can't do it. So the committee got together, got that to enforce the rules, but you can't enforce the rules with the dole care, and dole care is so little. And when dole care enforce the rules, you can't enforce the rules when they have no permit that's saying that they're not commercialized businesses. So we have illegal commercialized businesses there in Kaneohe Bay, over 100 right now. We started with 9 legal commercial businesses. The commercial businesses come on buses and vans and drop off at the pier. Today you come on any weekend and there's cars parked all the way down the stretch in Heia. Sometimes the 2 buses, city buses, cannot pass each other when they get closer to the pier. And this gotta stop. And we need to get this in rule, and we're in favor of making rules and regulations. Our family has been there for over 300 years now in the Hia'ahua'a. And both the Kahalua and Kaneohe Neighborhood Board strongly supports this bill also. I'm on the Kahalua Neighborhood Board.
Thank you.
But mahalo again.
Thank you. Next, we have testimony in support from Mahealani Cipher. Welcome. The floor is yours. Please proceed.
Aloha mai kako.
Aloha.
The Colau Foundation strongly supports this bill, which would prohibit commercial activities in Kaneohe Bay waters without a permit, as well as advertising for such regulated activity. Our organization is dedicated to the perpetuation of cultural practices and sustainability of the natural resources of our islands. We are especially concerned about the over-commercialization of Kaneohe Bay. This has been a growing problem for this important Windward Oahu coastal area, which has experienced significant growth in commercial activity over the past decade. Generally, a limited number of legal commercial tour boats are permitted in this bay, which conforms to the Kaneohe Bay Master Plan. Unfortunately, there are many unlicensed illegal tour companies operating in or using Kaneohe Bay and adversely affecting marine resources and the waters of the bay. I should note that we agree with the DLNR that they need more staffing. We always support the staffing. They are never staffed adequately. So if funding is needed, we also hope that you will change the time to this year, June, for it to take effect. And I also noted that the burden of proof is not on the department. The burden of proof, according to this bill, is on the commercial activity. So that's a good thing. I think that might help DLNR in dealing with some of these questionable actions. There's so much going on. What happens is the tour companies even send their customers with the kayaks over to He'ia, even though they're not from that area, they're from far away. They send their kayak customers over to He'ia. So it's a problem for everybody, but we wanted to make it safe for everyone. Many people are going to the Ahu'olaka, called the sandbar, and they're not supposed to. Commercial operations are not supposed to visit the sandbar, so that's another issue. But this bill would really help, and we wish DLNR all the best in hoping that they can conform with it. Thank you so much.
Thank you very much. Next, we have testimony support from Nancy Davientes, Dana Chiave, Joe Pickard, and L.K. Young. Anyone else here wishing to testify on House Bill 1134? If not, questions, members? Nope. Okay, we will go on. Thank you to those testifiers. We're going to do decision-making on this bill at the very end after everything, so that's the plan. There's no questions, though. Thanks very much for being here. Okay, back into our agenda where we left off. House Bill 107 relating to renewal of driver's licenses. Authorizes the renewal of driver licenses online or by electronic or digital means. First up, we have Department of Transportation. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, and members. Melissa Miranda Johnson with the Department of Transportation. We stand on our written testimony and support and available for questions.
Thank you. Next, we have testimony and support from City and County of Honolulu Department of Customer Services. Welcome. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members. The Department of Deputy Director Derek Maishera for the Department of Customer Services. We support this bill with a couple amendments. We're asking the committee to align the same requirements for renewal by mail to renewal by online applicants. And we're also asking for an amendment to push the effective date to July 1, 2025 to allow the county sufficient time to implement.
Thank you very much.
Thank you.
And we have testimony and support from Cards Pintor and from Dana Chiave. Is there anyone else here wishing to testify on House Bill 107? If not, questions, members. Representative Ganadin.
To the Department of Transportation. I can't think of a more popular bill than to end the lines at the DMV.
Yes.
What is the current, if you just know offhand, there have been a lot of efforts by your department to reduce wait times at various stations and satellite stations. What is the, how long does it usually take?
That's the city and county that would handle that, and state.
How long does it usually take to do a renewal of a driver's license?
Perhaps the city and county could
City and
answer
county.
that for you?
Yeah, city and county.
Thank you.
My apologies. Same
Thank you.
question.
We do make efforts to reduce the wait time for in-person renewals. We do that by having Aloha Q, our online renewal system. We do open that up. We do also take standbys to make up for those who are no-shows for the appointments that they do reserve online. I don't have the average time that it takes for a renewal online. I mean, a renewal in person for a driver's license. I'm not
quite sure what that is, but we try to get that process as expeditiously as we can.
Will this reduce the wait time at the DMV?
Yes, our hope is that those who elect to renew their driver's license online will free up additional reservation times on our Aloha queue system to allow more people to come for in-service transactions.
I can't think of a more popular bill, Chair. Thank you.
All right, thank you very much.
Thank you.
Anyone else wishing to ask questions? If not, we'll move on. Thanks very much to the testifiers on that measure. Next is House Bill 118, relating to traffic fines, clarifies that each county may by ordinance designate certain sections of county highways as areas in which stopping, standing, or parking vehicles is prohibited. Oh, I did. I skipped 494. Thanks. House Bill 494, relating to motor vehicles, subjects to the rights, responsibilities, and liabilities of transferees under the statutes, organizations that receive motor vehicles as charitable donations. We have testifier in support, Kalai Correa. Is there anyone else here wishing to testify on House Bill 494? If not, questions, members? If not, we'll move on to the House Bill 118, relating to traffic fines, clarifies that each county may by ordinance designate certain sections of county highways as areas in which stopping, standing, or parking vehicles is prohibited or restricted. For this measure, first up, we have Department of Transportation.
Good afternoon again, Chair, Vice Chair, members. State Department of Transportation stands on its testimony and support.
Thank you very much. And next we have testimony and support from the Hawaii State Association of Counties.
Hi, good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the House Committee on Judiciary and Hawaiian Affairs. Thank you so much for making time to hear this piece of legislation today. And I do have to say, in the context of everything else that you guys have been hearing today, this seems rather manini. But I did want to come in and make a personal plea on behalf of the counties for this tool. We're really looking for a surgical tool to allow us to address the issues related to people parking in illegal parking zones, particularly in areas adjacent to overly trafficked destinations. For example, in my district is Waipio Valley, and the parking in illegal areas there just causes so many issues with respect to safety, visibility through traffic. And in order for us to develop a long-term program, we need this tool in our toolbox to be able to identify some of these areas for a higher value parking ticket so that we can modify behavior for our guests and make sure that we're funneling the parking to the appropriate zone. So encourage and ask for the support of the committee today for this particular bill. Thank you so much.
Thank you very much. And we've received testimony in opposition from Gerard Silva and opposition from Dana Keave. Is there anyone else wishing to testify on House Bill 118? If not, questions, members? Seeing none, we'll move on. Thank you to the testifiers. House Bill 1294, relating to elections, requires every candidate for public office in Hawaii to use their legal name for election purposes. First up, we have testimony and support from Zeb Jones, and testimony and support from Nancy Jones, testimony in opposition from Cards Pintor, and testimony with comments from Gigi Zhong. Is anyone else here wishing to testify on House Bill 1294? If not, questions, members? Seeing none, we'll move on. House Bill 1152, it amends the period in which the Supreme Court and Intermediate Appellate Court are in session to June 1st of each year through April 1st of the following year. Specifies that the Hawaii Supreme Court and Intermediate Appellate Court shall issue decisions only during the time period these courts are in session, and requires a written decision to be issued during the same session in which the oral argument is heard. First up, we have testimony in opposition from the judiciary. Thank you for your patience. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. Thomas Berger, I'm a staff attorney at the Hawaii Supreme Court, testifying for the Hawaii Judiciary in opposition to House Bill 1152. Over the years, through collaborative efforts, the Hawaii Judiciary and the legislature have worked together to improve the efficiency of the appellate courts. Recently, in 2022, the legislature approved a new position for a 7th appellate judge at the Intermediate Court, allowing it to resolve cases faster. In 2021, the legislature passed House Bill 189, which also improved efficiency at the appellate courts by allowing the Chief Justice to temporarily fill a vacancy. Both of these measures had strong community support, and with their passage, the Hawaii legislature helped to establish an efficient and accessible court system for the public. House Bill 1152 before the committee would undermine these collaborative efforts by creating inefficiencies. For example, over many years, the Hawaii legislature has established priority for certain appeals, including child custody matters, some labor dispute decisions, and numerous other cases. House Bill 1152 would completely eliminate the priority system in April and May of each year. No decisions could enter during these months. Under the current system, the appellate courts operate in continuous session from January through December, allowing the courts to resolve cases, including priority matters, in every month of the year. In conclusion, the judiciary looks forward to continuing its collaborative efforts with the Hawaii legislature to establish an efficient and accessible court system, and would respectfully request this measure be deferred. Thank you.
Thank you very much. Next, we have testimony in opposition from the Office of the Public Defender.
James Tabe, State Public Defender. Good afternoon again, Chair Tarnas, Chair Takayama, Vice Chair Takayama, I guess Representative Ganadin. Yeah, we are opposed to this. Just for background, I was an appellate attorney for almost 20 years, so I'm quite familiar with the system here. I do think that there'll be several problems, and I think I highlighted them in my testimony. I tried to throw together late last night. For one example, there's certain deadlines, and we set this from in May and April and May. They wouldn't be able to follow statute, so they'd be breaking the law, so to speak. And also, there's important matters that what we call writ of mandamus or writ of prohibition. Those that the aggrieved party believes that they need immediate relief. And we have filed those, and some of them were granted by the Supreme Court on some of our cases. And if that happened to fall in April or May, we'd have to wait till June. So that wouldn't make too much sense. So again, also oral arguments, if they're going to, after oral arguments, it would be stacked in the beginning of the session, so to speak, because once you have oral arguments, it usually takes a long time to research, draft a well thought out opinion, which is set for precedent. So if you miss the beginning of the session, and if our case deserves oral argument, we would have to wait till the next session, so to speak. And again, so I do think this would cause backlog. So I am available for any questions. Thank you.
Thank you very much. And we have also testimony in opposition from the Hawaii State Bar Association Appellate Section, and testimony in opposition from Gerard Silva. Is there anyone else wishing to testify on House Bill 1152? If not, questions, members. Representative Ganadin.
To Mr. Berger from the Judiciary. It's rare that, I mean, my third year in office, I don't think I've ever seen a bill get this far with all negative testimony. So I'm wondering what from your perspective, the purpose of this was to limit the judiciary's ability to make decisions on a rolling basis, pursuant to your own rules.
I have no, I'm not sure. Yeah, I can't speculate on that. Yeah.
Was it possibly to align with the legislative session, or?
I'm not sure. Yeah.
All right.
I apologize.
Okay,
Yeah.
I'm just trying to get to the root of how this is even. Thank you.
Yep.
Thank you very much. Any other questions, members? If not, we'll move on. Thank you. Next, we have House Bill 386, relating to the safety of judiciary personnel, prohibits in certain circumstances the publication of the personal information of state and federal judges and other judicial staff whose duties put them at risk for acts of violence and threats. First up, we have testimony from Mr. Berger, Judiciary.
Good afternoon again, Chair Tarnas, Vice Chair Takayama, and committee members. As outlined in the written testimony, there have been some tragic events at judges' homes on the mainland, and in response, Congress recently enacted legislation to protect the federal judges. House Bill 386 before this committee does not go as far as this new federal legislation and would provide only a limited remedy for removal of personal information, such as a home address, from the internet when there is a clear risk of harm or violence to a judge, probation officer, or public guardian. In conclusion, the judiciary supports House Bill 386 and requests the committee pass the measure with the amendment to add reference to family court judges. Thank you.
Thank you very much. Next, we have testimony and support from the State of Hawaii Organization of Police Officers and testimony and support from the Hawaii State Bar Association. Is there anyone else here wishing to testify on House Bill 386? If not, questions, members? If not, thanks very much. Let's move on to the next bill. House Bill 1502, relating to evidence, limits compelled disclosure of sources or unpublished information for journalists, newscasters, and persons participating in collection or dissemination of news or information of substantial public interest. Establishes exceptions as well. On this measure, we have testimony with comments from the judiciary. And testimony with comments from the Office of the Public Defender. Okay, and then testimony and support from the Media Council of Hawaii. Chris Conybeare. Please proceed. The floor is yours.
Chair Tarnas and members of the committee, I'm Gerald Kato. will present testimony on behalf of myself and the Media Council of Hawaii. Your agenda is long, so I'll keep this short. I've taught journalism and communication at the University of Hawaii, and before that I was a newspaper and television reporter in Hawaii. I strongly support HB 1502 without amendments. The bill revives Hawaii's Reporters' Shield Law. A shield law gives reporters protection against being forced to disclose confidential information or sources in state court. It provides an incentive for vigorous and unfettered, truthful information to the public. I participated in negotiations that led to creation of what's become Act 210 in 2008. I believed then, as I believe now, that Act 210 is a valuable piece of public policy that balanced the state's need for evidence with robust protections for journalists and journalism. Act 210 has been reviewed by the State Supreme Court's Committee on Rules of Evidence, which supported codification of the Shield Law. I've spent the past 15 years working to see this legislation codified. And I've spent many more years before that working on behalf of protection of the First Amendment rights. This is the time for the legislature to act in support of those rights. Thank you very much.
Thank you very much. Next, we have testimony in support from the Hawaii Chapter Society of Professional Journalists.
Hi, Chairman
Welcome.
Tarnas and Vice Chairman Takayama. I'm Sterling Morita. I'm president of the Hawaii Chapter of the Society of Professional Journalists. We're really glad to see you guys take up this bill. This is a very important bill. It helps protect, it resurrects Hawaii's Shield Law that allows the reporters to protect identities of their confidential sources and to protect unpublished notes. It was a highly regarded law for 5 years, from 2008 to 2013. And we lost it when we couldn't get past the sunset date. We urge you to pass this bill. There's probably not a lot of laws like that. I don't think there's any other law like this, but it is a good measure. It never faced any real problems during the 5 years it was in effect. And in fact, it was only was used once in a case of a documentary filmmaker from Neighbor Island. We do, however, deviate a little bit from my friend Gerald. We think time has come. This bill was drafted in 2007. Things have changed dramatically in the media landscape since that time, and our friends that are doing as much good work and do as much work as I do, or as anybody else does in newspapers and stations, are not fully recognized in this bill. And we would like to see you add digital news websites to this and take out the portion about any digital version thereof operated by the same organization. That was relating to websites operated by the newspapers or the TV stations, and that's to avoid duplication. But this brings websites such as Civil Beat, who have become very important media players in town, into the full picture. And we think it would be a good amendment to make. So, but I appreciate you guys taking this up, and you have our full support. Thanks.
Thank you very much. And next we have testimony and support from the Big Island Press Club, testimony and support from Albatross News, Will Karen, Gerard Silva, and also testimony and support from Gerald Cato. Oh, okay, so you gave your testimony earlier. Okay, anyone else wishing to testify in House Bill 1502? If not, questions, members? If not, thank you very much. Let's move on. House Bill 209 relating to tourism requires the Department of Agriculture to include a statement on desecration laws in the plant and animal declaration form. For this measure, we have testimony and support from Dana Chiave and Regina Gregory. Is there anyone else here wishing to testify in House Bill 209? If not, questions, members? Seeing none, we'll move on to the final bill on our agenda relating to right of entry for professional surveyors. Authorizes professional land surveyors and assistants under the direct supervision of land surveyors to enter private property to perform land surveying, subject to certain provisions regarding notice, identification, and liability. Shields land surveyors and their assistants from prosecution under criminal trespass laws when performing their duties. First up, we have testimony with comments from the Attorney General. Welcome.
Thank you.
The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, Rep. Ganadin, Christopher Leong, Deputy Attorney General. You have our department's written testimony wherein we do oppose this bill as written, and that is because of the issue, with respect to the risk of potential takings claims against the state if this law is to be enacted. And that is in light of this very recent U.S. Supreme Court case that we point out, the Cedar Point Nursery case, in which a California state statute allowing access of parties onto private property of another was deemed to be a taking by the U.S. Supreme Court. And so, we want to alert the committee and the legislature to the fact that there is a risk that takings claims could be pursued, and this would result in an unknown amount of liability for the state if these claims are pursued. So we do offer some amendments, which is in the written testimony, to that subsection A on page 2. And then there's also a separate risk of takings claims with respect to the a liability shield for damages on property. And for that reason, we also recommend deletion of the subsection D of the bill. So that's it for the testimony, and I'm available if you have questions.
Thank you very much. Next, we have testimony with comments from the Board of Professional Engineers, Architects, Surveyors, and Landscape Architects. Sheena Choi.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Sheena Choi, Executive Officer for the Board of Professional Engineers, Architects, Surveyors, and Landscape Architects. The board would like to stand on its written testimony. Thank you.
Thank you very much. And next, we have testimony and support from the Hawaii Land Surveyors Association. Welcome. The floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Thank you for allowing me to testify in support of House Bill 1241. My name is Meyer Cummins. I'm a land surveyor licensed to practice in the state of Hawaii. I'm also a director on the board of the Hawaii Land Surveyors Association, which represents the majority of the licensed surveyors in the state. First, I stand by my testimony previously submitted in favor of this bill. There I included suggested amendments to, among other things, reduce the required notice to 7 days and clarify that surveyors shall not enter dwellings, structures, or vehicles on the access property. I also agree with the AG's office that subsection D, the provision that shields surveyors from liability for incidental minor damage, should be deleted. I brought a copy of some proposed provisions for the bill to give to the committee for its consideration. Second, given the nature of conducting a survey, the right of entry being sought is more akin to a mere occasional trespass rather than an unconstitutional taking. Surveyors generally do not return to or loiter on a surveyed property once the survey has been completed. The U.S. Supreme Court determined in the 2021 case Cedar Point Nursery versus Hasid that such occasional trespasses do not constitute a Fifth and 14th Amendment taking. However, even arguing that the right of entry constitutes more than a mere occasional trespass, the Supreme Court also stated in the Cedar Point Nursery case that there will be no taking where the government requires property owners to cede a right of access as a condition of receiving a certain benefit that is roughly proportional to the use of the benefited property. Here, land surveyors are licensed by the government to inspect, correct, and maintain a stable and reliable private property regime to maximize the exercise of a landowner's private property rights and reduce litigation that may occur due to disputes arising from boundary discrepancies. Additionally, an adjoining owner benefits from the common boundary being surveyed at the other party's expense. These benefits are proportional to the minimal access being granted to surveyors. Under this framework, a temporary right of entry for surveyors for the strict purpose of conducting a survey falls under the exceptions to the taking determination and should be permitted under the police powers of the state to benefit the safety and welfare of the community. Mahalo nui for this opportunity to testify. Should you have any questions, I'm available for questions.
Thank you very much.
Thank you.
Next, we have testimony in support, testimony with comments from Hawaii Realtors. Lindsay Garcia.
Good afternoon, Chair, Vice Chair, and members. My name is Lindsay Garcia from the Hawaii Association of Realtors. We support the amendments that were made in the previous committee. If the committee is inclined to pass the measure, we respectfully request additional amendments which clarify that the measure applies only to adjoining lands and not private residences, structures, or buildings on the property. Thank you.
Thank you very much. Next, we have testimony in support from Joanne Williamson.
Honorable Chair, Vice Chair, committee members, wow, the whole spectrum grew again.
Ta-da!
Ta-da! Oh, shucks. I strongly support the thoughtful amendments incorporated into the proposed draft presented to you by Mr. Meyer Cummins. Thank you.
Thank you very much. Next, we have testimony in support from James Seitz, Louis Pear, Victor Rasgado, Eric Kaneshiro, and then testimony in opposition from Dana Kiave. Is there anyone else here wishing to testify in House Bill 1241? If not, questions, members? If not, thanks very much. Thank you very much to the testifiers. I'd like to take a brief recess before we go into decision making. Recess. reconvening the House Committee on Judiciary and Hawaiian Affairs for decision-making. Just to make sure everyone knows, it's still Tuesday, February 28th. This is the 2 p.m. agenda, and we're going to move into decision-making on the measures that we had on this hearing agenda. First up, House Bill 777, with the concurrence from the Human Services Chair, I'd like to recommend amendments to adopt the amendments from the Department of Human Services and make some technical amendments. With that, any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 777 HD1 with further amendments, Chair and Vice Chair vote aye. Representative Ganadin?
Aye.
Representative Holt?
Aye.
Representative Hashimoto?
Aye.
Representative Ichiyama?
Aye.
Representative Ilagan?
Aye.
Representative Kong, excused. Representative Mizuno?
Aye.
Representative Souza?
Aye.
Your recommendation is adopted.
Thank you very much. Next, we have House Bill 823. On this measure, I would like to recommend passing out an amended bill, so that would be House Draft 2. I would like to change the effective date to upon its approval. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 823 HD1 with further amendments, noting the excused absence of Representative Kong, any WRs or noes. Seeing none, your recommendation is adopted.
Thank you. On next bill, House Bill 100. On this bill, I'd like to move it forward just for continuing discussion. I want to make some amendments to it. On page 2, line 8, should be specified that the working group is established to, quote, make recommendations for a statewide criminal justice data repository. On page 2, line 11, 15, and 19, and page 5, line 7, we should change the references to program and to repository, so we're consistent. I'm going to keep the blank end date for the working group, make some technical amendments, and defect the effective date to June 30th, 3000. With that, questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 100 with amendments, noting the excused absence of Representative Kong, any WRs or noes. Seeing none, your recommendation is adopted.
Okay, just a moment. On House Bill 1336, I want to commend the introducer of the bill and the previous committee, Corrections, Military, and Veterans, for their work on this, and also to all the testifiers, because all of your input is helping improve this bill, which is really a paradigm shift in the way we operate. The bill title is accurate, relating to criminal justice reform. And this, what we're seeking to do is to reform our criminal justice system in a way that is reasonable, but it's significant. So I recommend to the committee that we amend this measure, so a House Draft 2, and let me explain what I propose to do. We want to correct a typographical error on page 4 that I explained during the testimony, so that it would read, in any case in which it is lawful for a law enforcement officer to arrest a person without a warrant, as long as the person poses no significant danger to a specific or reasonably identifiable person, etc. So we made a mistake in a previous version, so we would correct that. So it's on page 4, line 18, change the word "a" to the word "no." On page 4 as well, to address concerns from prosecuting attorneys and the Attorney General, we'd like to, line 6, delete the word "felony," so that that if someone is arresting so that a law enforcement officer would not be able to give a citation to someone who may have committed a felony. On page 11, lines 16 to 17, I want to make sure that the bail, we want to make sure that the pretrial bail report shall be provided as soon as available. So we'll delete lines 16, 17, no later than the commencement of the bail hearing and shall be provided. On page 13, lines 5 to 6, delete the word flee, and that way what's left is the words willfully abscond, which is a more accurate technical term rather than flee. On page 14, lines 15 to 20, and on page 15, lines 1 to 2, we are deleting rebuttable presumption. Is that right? Yeah. So it's basically that whole section D that goes from line 15 on page 14 all the way to line 2 on page 15. On page 16, I want to, on line 18, change so that it reads now recently had 1 positive test for drug use. On page 21, lines 1 to 2, same thing. Defendant had 1 positive test for drug use. On page 21, lines 7 to 8, we have to underline the words "or knowingly" because that's new language. On page 21, line 13, we want to add, quote, "a violation" after established, so it reads prosecution to establish a violation. So we're correcting that one. Page 23, lines 6 to 9, delete, quote, "any party representing the defendant or information to the court concerning the defendant may request that," and just add the word "may" to line 9 between court and order. That helps to address a judiciary concern. On page 23, lines 13 and 16, we're changing the language so that it reads defendant having 1 positive test for drug use. On page 23, lines 21 to 24, we're going to, from page 23, line 21, all the way to page 24, lines 1 to 2, we're deleting "any party representing the defendant or information to the court concerning the defendant may request that," and we add the word "may" to the line between court and order on line 2. Okay, on page 24, lines 11 to 13, make the same change. Page 25, line 4, make the change I referred to earlier, so that it reads defendant having 1 positive test for drug use. Page 26, line 9, change to make the same change that I just described. And then we need to make some changes to the summary of the description of the bill as well to reflect the changes that we've made in the bill itself. I know it's a lot of changes. I didn't have a House Draft 2 to present to you, but I appreciate the members for taking all these changes that I've described to you. And with that, I would ask your questions or concerns. Anybody wishing to? Yes, Representative Holt, please proceed.
Thank you, Chair. Going to be voting no on this measure. You know, throughout the testimony and the questioning, I don't see any real reason to pass this measure other than overcrowding, which I feel we can address with building a new jail. I also feel the 48-hour grace period is very vague, as the public defender noted. And, you know, I also feel that part of my job is to be an example for our community and our keiki. And by giving this 48-hour grace period, I don't know what kind of example we're setting by saying court is not important and you can show up 2 days later. So I don't think that that's a good message for us to be sending. And, you know, when is it enough? And, you know, and I understand, you know, best practices in working groups. As far as the drug testing portion, I don't know all of that information, but I do speak from personal experience. And, you know, one of my immediate family members was in this particular situation. And it was a positive drug test that put them away and got them better.
And if not for that, what would happen? So, you know, people in the audience can shake your head at me, but this is what I've lived through. And I think that my community was very vocal when we passed a measure similar to this that was vetoed last year. And I was asked many times, why are we passing this measure? Why are we going down this route? So I thank you for all the work on this bill, Chair, but I'm going to be voting no.
And I fully understand that and respect your decision to represent your community that way. Thank you for explaining it. I do want to note that we should also make some technical amendments to the measure. I should have said that when I made my recommendation. So all the recommendations I made plus some technical amendments. Okay, other questions or concerns, members? To you, Representative Ganadin.
Thank you to the work put in by members of the community, those who testified, Chair, and everybody discussing this. The individuals that we're discussing pertaining to this bill, people who are facing petty misdemeanors and misdemeanants, these represent, according to the task force that came to the state a few years ago, around 75% of the people who are held pretrial. They are many of the folks that are facing mental health and addiction issues in our community. And in other places around the country, they consider their pretrial detention a human rights violation. In the 48-hour discussion, this comes from large rural states, and just as a background, everything in this bill was passed in a bipartisan measure over the last decade across the United States. So there's nothing really original or all that creative in HB 1336. It's only kind of creative because we haven't heard it before in this committee. But the 48-hour thing, that comes from big rural states where people can't make it to court, and I'm really surprised to hear the testimony against it in communities where, you know, people have a hard time getting back and forth to court, and where we've actually got best practices after COVID where people got to zoom into court and appear and let the court know that they're not trying to abscond, they're not trying to leave, they're not trying to commit new crimes, they just can't make it in. I also realized that this is what democracy looks like, that we start out with a draft, we hear from numerous individuals and stakeholders, and we come up with new and better drafts. And most everyone that testified suggested that we need significant reform in the criminal justice system. And I think that this bill takes major steps toward that end. Thank you.
Thank you very much. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1336 HD1 with further amendments, noting the excused absence of Representative Kong and the no vote of Representative Holt. Any other reservations?
Reservations.
Reservations for Representative Hashimoto.
Reservations.
And Representative Souza. And Representative Ilagan. Chair, your recommendation is adopted.
Thank you very much. Next, moving on to House Bill 125. I would like to recommend that we defer this measure because I would encourage the prosecuting attorney to work with the Rules of Penal Procedure Committee to see if they can amend Rule 43 to address their concerns. On Senate Bill 36, this is an important measure. It's a compromise measure that has gone through a lot of different versions, and I think it has the necessary support to move forward. My recommendation is to move it forward as is. Questions or concerns, members? Representative Ganadin.
Chair, I'll be voting with reservations. I do not believe the paragraph on page 4 discussing good cause passes constitutional muster.
Thank you very much. Other questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 36, passing as is, noting the excused absence of Representative Kong and the reservations of Representative Ganadin. Any other WRs or noes? Seeing none, your recommendation is adopted.
Thank you very much. Next. House Bill 107, I would like to recommend that we amend this measure, so we'll have a House Draft 1 going to take the amendments as recommended by City and County of Honolulu Department of Customer Services, and I'd also change the effective date to July 1st, 2025. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 107 with amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 494. I would like to recommend House Draft 1 to defect the effective date to June 30th, 3000, and move it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 118 with amendments. I'm sorry.
494.
Oops. Oh, okay. Sorry, Chair.
That's all right. I got your back. You saved me a number of times. Now it's my turn. House Bill 494, recommendation House Draft 1, defect the effective date 6/30/3000.
Voting on House Bill 494 with amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 118, relating to traffic fines, recommendation is to pass this as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 118, passing as is, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1294. I'd like to recommend we amend the measure, House Draft 1, defect the effective date to June 30th, 3000, and pass it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1294 with amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. House Bill 1152. Nobody likes this bill. We have unanimity between the prosecutors, the defense attorneys, the judiciary. Everybody doesn't like this bill, so we're going to defer it. And I told the introducer of the bill, so he knows, he's not surprised. Okay, moving on, House Bill 386, relating to the safety of judiciary personnel. I recommend we pass this out with amendments. I'd like to make the amendment as recommended by the judiciary and make some technical amendments as well. And I'd like to keep the clean effective date, so we can move this along. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 386 with amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. On House Bill 1502, I'd like to accept the recommended amendment from Mr. Morita. I'd like to defect the effective date to 6/30/3000, and with that, pass out a House Draft 1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1502 with amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1134, relating to Kaneohe Bay. I'd like to recommend moving out an amended bill, so that'd be House Draft 2. The amendments I'd like to make are the following. I'd like to make some technical amendments and specific amendments on page 4, line 14 to 15. Change the word part to section, so that that's clear. On page 9, line 5 to 6, specify that instead of Hawaii Harbor Police, I would say Division of Conservation and Resource Enforcement. Page 10, line 20 to 21, delete the words "or board." And then I want to note for members that there is no referral for this bill to Finance Committee. Therefore, we really should not have an appropriations section here, so I would like to delete the appropriations section, which is section 4. And then we'd make some technical amendments as well. With that, I'd like to move it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1134 HD1 with further amendments, noting the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. House Bill 209, it's already got a defective effective date. Let's move it forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 209 HD1 passing as is with the excused absence of Representative Kong. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. On House Bill 1241, my intention is to pass this out with amendments, but we've got some more work to do on these amendments. And I appreciate all the testifiers from the surveyors, and I assure you, my intention is to pass this out. I want to put it on the decision-making. I want to defer decision-making to Thursday, March 2nd agenda at 2 p.m. I have to basically make sure that all the testimony from Mr. Cummins, the realtors, the Attorney General, and the CPC chair are all included, and that we make sure they're not conflicting. So we're going to work on that. I'll come back to the committee with a proposed HD2 on the agenda on Thursday. So that's the plan. Okay? There being, oh yes, I have to announce it. The decision-making is deferred to Thursday, March 2nd, 2 p.m. in conference room 325 at the State Capitol. Everybody knows, okay? There being no further business before this committee, we are adjourned.